Ankita Satpathy representing Mahdi United Nations. Thank you, Madam Chair, and I'd like to reserve the right to yield any remainder of my time to my closing speech. I'd like to share a story with all of you today. This is the story of a woman named Sabrina Butler, a young mother who was given a life sentence in jail for the death of her infant child. And after serving 6 years of that life sentence, new medical evidence came out, and it came out that she was completely innocent, and she was exonerated. But it took another 17 years after that for her criminal record to be expunged. And why is this a big deal, you may ask? Because during those 17 years, it became immensely more difficult for her to find housing, for her to find employment, and even to access her other civil liberties such as gun rights. And this is something that is affecting thousands of people in America today. Currently, the process to get a criminal record expunged, even for those who have been exonerated, can take decades of appeals, sometimes to the governor, sometimes it requires proving innocence a second time, and all of this is completely unjust and unnecessary. The only two states that offer streamlined processes are New York and Illinois. So why is it that we don't expunge these records that are false to begin with? Well, I'd love to know, because this isn't something we should be doing. These are people that have already been failed by the justice system. Why do we continue to make their lives harder when they did nothing wrong? But the solution is simple. I propose that we implement a federal law to automatically expunge criminal records for exonerated people. And furthermore, that there be a committee formed under the Justice Department that will ensure that the names of these people and their records remain off any database accessible to the public that is not a government database. And how is it we can do this, you may ask? Because once these records are on other databases, they are now false, and thus they are slander and libel. So the government has the ability to remove them from these databases and give people their liberties back. There are some proposals that appeal to logic, some to emotion, some that are financially sound. But this is something that checks off all three of those boxes. It just completely doesn't make sense to deprive people of their livelihoods and civil liberties who have done nothing wrong, and I hope that you feel some compassion for Sabrina Butler and the other thousands of people like her. The only money that this proposal spends is the committee formed, and because that is under the existing Justice Department, it would primarily just be a reallocation of funds. So with that being said, I really do hope that you consider this proposal and think about all of the lives that are being affected by this when you vote. Thank you, and I will yield the balance of my time to my closing speech.
Thank you. You've yielded 1 minute and 30 seconds. The floor is now open for 4 minutes of non-debatable technical questions. Colorado, Texas, Maryland, Massachusetts, New Mexico, South Carolina, Texas, Virginia, Massachusetts, Tennessee, Maine, California, Texas, Louisiana.
The estimates from the Republic of Texas. Thank you, Madam Chair. Can you explain the current process to exonerate criminals?
Please be brief.
It varies state to state and requires many appeals.
Thank you.
Thank you, Madam Chair. Sean Toomey, Massachusetts delegation. What percentage of convicted felons have been found innocent?
I don't know.
Thank you. Next question.
Vine Topper from Colorado. Is this exclusively for DNA-based exonerations?
Yeah. Sam Lawrence from the Republic of Texas. What is the average cost for an exoneration?
I don't have that.
Thank you. Next question.
Georgia, Random, Massachusetts, will this apply to criminals that are already exonerated or criminals exonerated in the future?
Both.
Catherine Long, Commonwealth of Virginia. What is the percentage of these criminals who re-enter society have multiple crimes on their records?
I do not have that statistic.
Thank you, Madam Chair. Ethan White from New Mexico. So how many exonerated criminals are there in the United States currently? Do you have that number?
1,610.
Cameron from Commonwealth, Massachusetts. Does this apply to criminals who are exonerated under technicality?
Yes.
Brady Groton representing the Maine delegation. Thank you, Madam Chair. You stated that Sabrina Butler took 17 years. Do you know what the average amount of years it takes for criminal record expungement?
A decade.
Thank you, Madam Chair. Rose Porter, Massachusetts delegation. Will this proposal assist those exonerated in re-entry into our society?
Yes, by erasing their record.
Tony Brisson, California. Thank you, Madam Chair. What is it about the process in particular that makes it so hard to erase these records?
That's debatable. Next question.
Hi, Sammy Stram. Thank you, Madam Chair, from the Republic of Texas. Just to clarify, on line 28 through 29, would the time already served count towards their sentence, or would they serve a new set of time to serve their sentence out?
Once they've been exonerated, they're no longer serving a sentence.
Lucas Clamrock, South Carolina. Thank you, Madam Chair. You stated that it would just be a reallocation of funds. What program would be losing money?
This is a proposal that's not specified.
Thank you. Next question.
Kamar Mack, Tennessee. You mentioned 2 states with your proposal in place. Do you have any information about when they put it in place? Like, when did they start it?
Speedy Billings from the Free State of Maryland. How quickly will databases be cleared under this proposal?
It's a proposal, so that isn't
Thank you. Next
specified.
question. More non-debatable technical questions. New York, Wisconsin, South Carolina, Kentucky, Texas, Virginia, Kentucky, Florida, Maine, Arizona, Oklahoma.
Delegation, Wisconsin delegation, thank you, Madam Chair. So if a criminal who has been exonerated and then commits another crime, does the Department of Justice take away their expunged status?
No, it's only for the crime that they've been exonerated for.
Whitley Drinker, Commonwealth of Virginia. What percentage of exonerated criminals are exonerated on technicalities?
I don't have
Thank you. Next question.
Alex Grove, representing the Commonwealth of Kentucky. Madam Chair, does this apply both to federal and state courts?
Yes.
Forrest Courtney, representing the Commonwealth of Kentucky. Thank you, Madam Chair. Author, you stated that these records will be expunged from public records. However, will they say governmental records unaccessible to the public, like police reports and things like that?
Not in the police reports of the public.
Thank you. Next question.
My question was answered.
Thank you, Madam Chair. Hannah Pearson, the Republic of Texas. In reference to line 27, are the records of exonerated criminals not expunged within the system as it currently stands?
That's not automatic. Thank you.
Thank you, Madam Chair. James Caswell from New York State. In here it says that the charges must be expunged automatically, and that if they don't, it becomes slander, but it doesn't specify how quickly it automatically is. So will these people be able to bring a civil case against the U.S. Justice Department of slander if they cannot expunge it automatically, in their opinion?
No, automatically we'll have the right to
Thank you. Next question.
Thank you, Madam Chair. Brady Brown, representing the delegation. Does your proposal suggest that if these public databases refuse to remove the information, that the Department of Justice will take legal action against them?
Not necessarily, but it will.
With that, the time for non-debatable technical questions has elapsed. The chair will recognize the calm, intent speaker. The chair recognizes Franklin. You have 3 minutes for your statement.
Ladies and gentlemen, I'm making this statement because I believe the basic civil rights are pretty clear. But the proposal on the floor seems to want to take away some of our civil rights. And I don't like that. You shouldn't like that either. I know some of you are out there rolling your eyes thinking, oh, God, another lecture about the Constitution. No, listen to me. This is important. This proposal seems like it's doing a good thing. Like it's trying to protect the innocent. I'm all for that, for the protection of the innocent. That's exactly why I thought you opposed it. It limits the freedom of speech and of the press. Now, it's not super blatant. I'm not comparing the proposal to the Big Brother, but it definitely does limit our freedoms. It sets a precedence for the government to have authority over things people should do. As the saying goes, we give an inch, they take a mile. The government has no place in restricting free access to the internet, and that includes any public, non-governmental criminal databases which might happen to be found. This proposal says that the government can decide that something a private citizen freely publishes is wrong. I will concede that it is wrong that some of the posts are directly communicating with others, but unfortunately, Sabrina's legal misfortune doesn't mean that other people need their civil rights taken away. The fact of the matter is that while we may not agree with what someone says, we must always defend the right to say it. Any supporters of this proposal might try to claim that this actually protects people's rights, saying that this protects the principles of due process, but it simply goes too far. I might support it if it was framed in the context of existing libel and slander laws specifically. I might support it if it focused on just the government's official databases. I might support it if it focused on streamlining communication updates in the criminal justice system. I might support it if it upheld the internet as a refuge for free speech, but no, it does none of these things. Okay, to make my argument more practical, I'm going to tell a little story. Ryan Braun is an outfielder for the Milwaukee Brewers. In 2011, he tested positive on these performance-enhancing drugs. After he appealed the decision finding him guilty, he was exonerated on account of a technicality. This is a huge oversight in this proposal. The fact that exoneration doesn't 100% guarantee innocence. It's not uncommon that people who were exonerated, found to be innocent, were in fact very guilty for their crimes. Though he was never convicted, look at the obvious example. O.J. Simpson, a man exonerated of crimes he obviously committed. I mean, even look at President Richard Nixon, who, even though he was never convicted of his crimes, was exonerated anyway. Provisions of this proposal are weak. They would never hold up, not legally, not morally, not practically. It contains huge oversights. But most importantly, the proposal limits civil rights entrusted to you and me, and I'm mad about it, and you should be too. Thank you. I give my time to the chair.
Thank you, Delegate. The chair recognizes the pro-intent speaker. The chair recognizes Davis of Maine.
Thank you, Madam Chair. I'm Justice Davis from the great North State of Maine. I rise today to advocate a proposal that just makes sense. Thousands of people who have been wrongly convicted of various crimes are still being denied their rights as if they were still guilty. If you're not guilty of a crime, why should you pay the punishment of being so? I know I would not want to suffer those consequences, and this proposal helps guarantee that exonerated convicts will be able to get back to living the lives they had before their wrongful convictions. Exonerated criminals, by definition, are not guilty of a crime in the eyes of the law. Oftentimes, the proof of their innocence comes years after they're actually sent to prison, and in many cases, they've lost years for absolutely no reason. Just as the previous delegate said in the case of Sabrina Butler, who lost up to 17 years of her life. Unfortunately, many of these exonerated men and women continue to be treated like convicted criminals because their records still show their convictions that were done wrongly. They did nothing wrong, yet they still have a hard time or are completely incapable of voting, renting a home, buying a car, purchasing firearms, when these rights should not be taken away from them. They are not guilty in the eyes of the law. Even if they are exonerated on a technicality, they still should not suffer the consequences of something that they completely never did. This proposal will help ensure that this unfair discrimination never happens again. Some of you may still have concerns, such as if their whole record would be removed. It's only removing the records of things that they have not done or have been proven to probably not have done in the eyes of the law. They still currently, expungement often requires months or even years of legal red tape before they can return to their lives. All this is doing is just simplifying that process. They no longer have to go through thousands of dollars, up to a dozen years of appeals in courts. Now they can do it as quickly as they want and as quickly as they need to have it done. Thank you. I yield the remainder of my time.
Thank you, Delegate. The time is now for con pro debate. Is there a con speaker on the floor? The chair recognizes Gross of DC. Please make haste.
Thank you, Madam Chair. Washington State.
That's your right.
Does the author
do you yield to a series of possible questions? Yes.
I just have one question. Say a person is charged with double homicide, and it comes into evidence that one of the victims were killed by someone else. Would it still expunge the double homicide, or would it bring it down to just the homicide?
Only the crime that they were exonerated for is expunged.
I mean, if the crime is charged with double homicide, and appears to not have been killed by that person, by the actual person being charged with it, would they take it down to a double homicide?
Yeah, they just have the record for the person that they did kill.
And I yield.
Douglas Corzine, Tennessee. First of all, I'd like to point out that the concerns raised by the con speaker were valid and extremely concerning. I'd also like to draw your attention to something that has been misstated several times in the debate on this proposal. We need to draw a distinction between libel and slander. Written defamations, including false criminal records, qualify as libel, while slander pertains to false speech alone. And the implication by multiple previous delegates that any exonerated criminal with libel slander is patently false. As a result, the current proposal is being falsely represented. I'd like to make this clarification so that we can get back to debating the actual issues at hand. Thank you, and I yield the remainder of my time to the chair.
Thank you. It is now in order for a pro speaker, such speaker present. The chair recognizes Canavan of Connecticut. Your time's done.
Madam Chair, and I reserve the right to yield the remainder of my time to Delegate Scanlon from Missouri.
That's your right.
Fellow delegates, this is an extremely important proposal to pass. It is unfair that these victims of our Justice Department's failures continue to suffer for years due to blatant laziness of our Justice Department. If these victims suffered unjust punishment for a crime they did not commit, the least we can do is make sure that their criminal records are actually truthful after they are exonerated. Under the status quo, exonerated citizens are being held back by their incorrect criminal records and therefore are unable to contribute to our economy to their full capacity, which is an embarrassment to not only our justice system, but also our nation. I yield the remainder of my time to Delegate Scout from Missouri.
1 minute, 2 seconds.
Thank you, Chair, and thank you, Delegate. Chase County, Missouri delegation. I'm all a fan of free speech and a fan of the Constitution and civil rights, but this is an issue more of civil rights. This is an issue of justice. These people have done absolutely nothing wrong, and yet they're suffering as a result of it. This is the worst fear that I can imagine. You do nothing wrong in your daily life. You walk through, and all of a sudden you are convicted of a crime you didn't do. You finally go through this hell of going through prison. You finally get out. You think you've reached freedom. You get back to the real world, and you find out you're treated like a second-class citizen for something you didn't do. This is a horrible stain on the American Constitution. We are to use this more than civil rights. This is justice. We are an injustice to our citizens of the United States. We owe it to these 1,600 people that are treated as second-class citizens for a flaw in the justice system. This is punishing people for something they didn't do. I cannot stress this enough. This is injustice in the American society. If we look to the European Union, where they have the right to be forgotten, which is much more controversial than this, where it's passed, where even if you are convicted, you have your right to be revealed. But this is what we're looking to, the rights of
Thank you, Delegate. The Chair will entertain a con speaker. The Chair recognizes Kentucky Grove.
Alex Grove, representing the Commonwealth of Kentucky, Madam Chair, and I reserve the right to yield the remainder of my time to Delegate Wright from Kentucky. First off, I have no issue with trying to help these innocent people that have been unjustly sentenced. However, my issue lies with an answer that the author gave. The author stated that this would apply to state and federal courts. Let me read you a part of our Constitution. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively. The author needs to show Supreme Court precedent or a portion of the Constitution that can justify such an action. The Supreme Court has ruled that the government can't actually interfere with state courts unless there is a constitutional provision. Therefore, I urge you to consider that this will only apply to state courts and not federal government. I yield the remainder of my time to Delegate Wright.
Evan Wright from Commonwealth of Kentucky. Just because you're found not guilty by a court doesn't mean a citizen isn't able or shouldn't be able to say that you're guilty. Just because someone's not guilty doesn't mean someone has the right to hold a database somewhere saying that a set of citizens are guilty of a crime. Because sometimes, as another delegate said, you're let out on a technicality where it's very debatable if you're guilty or not. They could not register a piece of evidence against you, but have all the evidence that points that you murdered someone or raped someone, but you get let out on one technicality, and people have the right to know that you went through that criminal process and that you may have committed that crime. It's debatable whether you committed that crime, and I understand that federal court systems should take their records off, but also, as another delegate said, it's a state right to say whether you're exonerated or not. We can't just disregard the Constitution. It's unconstitutional, and this is an amendment to the Constitution. This is a proposal for the federal government. Thank you.
Thank you. It is now in order for a pro speaker, such a speaker present. The Chair recognizes Marzella of New York.
Sarah Mazzarella, New York State delegation. I reserve the right to yield the rest of my time to Zua from Delaware.
That's right.
We need to do what we can to help these people back on their feet after we have failed them, not just once, but twice. We are leaving innocent American civilians to live with the burden of a crime that they have never committed. They do not deserve to have simple civil liberties such as the right to vote taken away from them just because they were wrongly convicted. The justice system has failed them once, and now they are going to fail them again, and they deserve to have these crimes expunged from their system. Thank you. I reserve the rest of my time.
Thank you. Mabel D'Souza, Delaware delegation. Thank you, previous speaker, and thank you, chair. So to address another con point brought up, just because you've been exonerated on a technicality means that you are legally innocent in the eyes of the court, and you should be treated as such. In Wisconsin, Audrey Edmonds served 11 years in prison for a similar crime such the death of an infant girl. In 2008, a mountain of new medical evidence, a higher court overturned her conviction and set her free, but her conviction popped up on a background check, and that is not fair. I would like to reiterate that this poor woman spent 11 years in prison, which is a fate I would never wish upon another person. Because as Orange is the new black states, prison is a hard life, and to deny any aid to the wrongfully convicted is quite abhorrent. And this proposal allows for those who are exonerated to start their broken lives over for free because their lives should have never had to pause in the first place. I would like to yield the remainder of my time to the chair and commend the author on this wonderful proposal.
Thank you. It is now in order for a con speaker. The chair recognizes Cooper of Tennessee.
Simon Cooper, Tennessee, may I reserve the right to yield the remainder of my time to Benson from Washington.
Measure right.
If you all will direct your attention to line 20 of the justification, it shows that only 2,000 people have been exonerated in the past 2 decades. That's about an average of 100 people per year. We have to remember that during the same time, literally millions of prisoners have moved through our criminal justice system, many of them unfairly sentenced for crimes they did not commit. We have to remember that minimum sentencing laws are incredibly harsh and that minorities are sentenced at a much higher rate than any other group. That includes ethnic and economic minorities. But right now, today, the Justice Department is in the midst of reforming itself and making sure that it doesn't prosecute these ethnic and economic minorities unfairly. We can't distract the Justice Department from the important work that it's doing for a little bit more bureaucratic efficiency. It's important that people who are exonerated are treated fairly, but it's also important to make sure that people aren't put in prison in the first place. And I fear that if we shift the attention too much to a more efficient exoneration process, what we'll be doing is distracting important personnel in the Justice Department with attempting to expunge records from privately held databases, which has questionable legality, and instead we'll be using enormous resources for these 2,000 people, when instead we have literally millions of people who are suffering under the current system who could be helped by the same professionals. I yield the remainder of my time to Vincent from Washington.
30 seconds.
Thank you, Tennessee, and thank you, Madam Chair. Matthew Benson, Washington State, Washington State. Since there currently is no Supreme Court case that says the federal government has the right to do this, I do believe that this is in violation of the 10th Amendment. And if the author does know the case that it does say that this is legal, I would ask the author to answer that in her closing summation. But since there is none at this moment,
Thank you. It is now in order for a pro speaker, such a speaker present. The chair recognizes South Carolina Micalo.
John McCullough, South Carolina. I'd like to
Please clear your placard.
I'd like to reserve the right to yield the remainder of my time to Texas Lawrence.
That's your right.
I'd just like to make a point about the technicality issue. So, it was raised that technicality should be a reason why we shouldn't allow exonerations to be expunged. But technicalities are problems within our laws already written, and that should be addressed in a different setting, not in this proposal. Also, as a previous speaker said that when people are let go on technicalities, it is debatable that they are guilty. But I am a firm believer that if we live in this United States, we are innocent until proven guilty, not if it's a debatable question. All right, thank you. I yield my time to Texas Lawrence.
1 minute, 20 seconds.
Sam Lawrence from Texas. I just wanted to refute a few points that the previous speakers
have brought up. Firstly, these are not news articles that are on private servers. This is not an opinion article that they are guilty. These are official government documents that state that they are guilty. We're not removing the rights of any Americans to write what they want, to have their opinion. This is legal documentation that's still stating that they're guilty after exoneration. Secondly, if a previous point was brought up that this is going to bog down the Justice Department, I am offended that we are letting our exonerated American citizens get bogged down by the Justice Department and continue to be portrayed as guilty. Once again, this is actually creating a new committee. This is creating a new committee that is not going to be considered part of the current Justice Department. It will be under it, but it will not be bogging down anything. This is a point for our American citizens to be free when they are free. When American citizens should be free, they should not be portrayed as criminals for the rest of their lives. Thank you. Any other remainder of my time with the chair.
Thank you. It is now order for the final con speaker. Is such a speaker present? The chair recognizes California Augie.
Thank you, Madam Chair. I reserve the right to yield the remainder of my time to Ashburn, Texas.
That's right.
Delegates, you have heard many that.
Delegate, can I say your name and delegation?
Daniel Aldi from the California delegation. Delegates, you have heard many valid reasons why this proposal should not pass, but for those of you in support, I say that this proposal does not do enough. 23 states lack statutes to provide restitution to exonerees, and even in the 27 states that do, many laws only provide the exonerees with the right to file for damages within a specified time after their release. 1/3 of people exonerated after proving their innocence have not been compensated. Providing these exonerated criminals with a better environment to find work after leaving prison does nothing if they don't have the money to get back on their feet first. It's hard enough for a young, intelligent graduate with a bachelor's degree to find work in this country. Imagine how hard it must be for someone who's wrongfully suffered in prison for years while generating zero income to do the same thing. Thank you, and with that I yield my time to Ashby from Texas.
Arnold Ashby, the Republic of Texas. While I am not saying that there is not a problem with exonerees and the way we handle them, this proposal does not help solve the problem. As stated during cross-examination, the proposal author stated that this would have, and the federal government would push to have these records removed from private servers and not being able to be found on private websites that do background checks and other background check websites. However, she continues to point out that the federal government will push to have these records removed immediately. I'm not sure if any of you have ever had to deal with the federal government, but they don't do anything immediately. They are terribly inefficient, and while we will be creating a new commission, nothing happens immediately with the federal government. She continues to go on to say that if this doesn't happen immediately from the government, these individuals have the right to sue, and not only do they have the right to sue the federal government, they also have the right to sue these independent websites. However, while you may not agree, and while the court cases may say that these people have been technically exonerated, these individuals and these people who own these background check websites still have the right to say whatever they want. You cannot force people to take stuff down just because you don't like it. If you could take down anything that we didn't like on the internet, there would be no such thing as a YouTube comment section. Quite simply, you can see that this simply limits the freedom of speech. The technicalities and the issues are ones that still have to be addressed. Because this does not do that, we must stand against this proposal. With that, I yield my time to the chair.
Thank you, Delegate. The time for Conpro debate has elapsed. Author, you are recognized for your 3-minute and 30-second closing summation. Begin when ready.
Ankita Satpathy representing Mali United Nations. Thank you, Madam Chair, and I'd also like to thank the committee for that debate. That being said, I will start by addressing some of the cons. So first of all, it was brought up in several speeches that this is somehow unconstitutional and it somehow violates First Amendment rights. Okay, well, you know what's not protected under the First Amendment? Libel. This is not unconstitutional. When you have records on the internet for crimes that someone didn't commit, that's false, that's libel, and it is illegal. So there's nothing unconstitutional about this proposal, and it was also brought up that this takes away civil rights. What civil right does this take away? The right to discriminate? The cases that were brought up by that con speaker, it was stated that they were extremely high-profile cases. So yes, there are going to be maybe 5 cases that people are still going to have information about and still going to be online. But since when